Hey, this is Politics with Laura. Okay, we're in the last. Fani Willis's closing arguments. Okay, I feel safe to say that Fanny got kicked. I mean, I don't. This case has been so crazy. I don't even know where to begin. I truly don't know. Everything has come out. Everything that is going to come out has come out. Don't know how the trial is going to go, but right now they are making the closing arguments as far as what information is going to be presented for the record. And keep listening for the record. Fani has padded her record. Nathan has padded his record. So they put a lot on the record so that they can maneuver through. Let's keep that in mind. But it doesn't take away the fact of the information that has been presented. I'm going to leave that right there. All right, let's go ahead and get this started. All right. Now, I'm going to jump through this. So I'm just going to allow the judge to talk so that you can get an understanding of what's going to happen. Oh, man.
Just for the record. Mr. Abadi, anything the state wants to add as it relates to Exhibit 39?
No objection from the state.
I have a copy for the court reporter. I printed a copy out and then I sent it along.
All right. If you've got that marked and stamped, we'll provide that to the court reporter. All right. And then, as I'd indicated as well on Tuesday, both parties since the close of the evidence on the 16th had followed up. Now I think both sides have made requests to reopen the evidence. On behalf of the defense, there were some issues with cell phone records, and the state has found an additional witness that they would like to present. And the instruction I provided on Tuesday was that for today, I think...
Okay, I'm sorry, I don't mean to stop it. But you heard him say that they are petitioning to reopen evidence. Oh, to reopen the evidence. Oh, man, that's going to be so bad, so bad. Okay, I'm done.
We've reached the point where I'd like to hear more of how some of the legal arguments apply to what has already been presented. And it may already be possible for me to make a decision without those needing to be material to that decision. So that's why we're here today. I wanted to make sure we held this time because it is a bit of a logistical challenge to get everyone in a room together. But recognizing that, again, in the interest of efficiency, if both parties want to reserve part of their time to argue as if those proffered exhibits have been admitted, feel free to make whatever arguments you would like. And if, in fact, it turns out that I do need those to be part of the record to make a decision, then we'd have to come back, and we will do those in accordance with the rules of evidence.
I want you to know what proper evidence is for those of us that have $7.50 worth of law, okay? All right. Proper evidence is evidence that is formally presented before a tier or a fact, including, or for an example, the jury, a judge or jury, to consider deciding the case. So they're bringing it in front of the judge, okay? $7.50 worth of law. I'm so silly.
May it please the court, Your Honor, John Merchant on behalf of Mr. Roman. Just by way of roadmap to give you some idea about the allocation of time and what I'm going to be covering. I've been charged with talking to Your Honor about the conflict issue and the appearance of a conflict and what we believe the evidence to show on that issue. Mr. Sadow, Mr. Gillum will be talking more about the forensic misconduct piece of it. Ms. Willis's church speech, statements made to the media, fraud on the court, frankly, and the book that she gave several interviews for. So I won't be discussing any of those issues. So if you'd like to ask me, certainly I can try to address them, but that's going to be the focus of their presentation. And then towards the end, other folks may have issue-specific type arguments, either in follow-up to mine or the forensic misconduct. But those are the two lanes that we're going to be covering, but I'm going to do the conflict piece of it for you. And on that issue, Your Honor, this is a matter of first impression in Georgia. I can't find a single case that's been published by the Court of Appeals or the Supreme Court that is based on these facts. There are, of course, a number of different appellate court cases that deal with conflict-related issues and, more importantly, appearance of conflict-related issues. And some of those are in state law. Some of them are based on the ethical rules that govern lawyers. Some of them are based upon the Sixth Amendment right to due process that's implicit in all of what we're doing here today. I want to remind the court that we're here today on this motion to disqualify DA Willis and her office because of her judgment, frankly. She is supposed to be disinterested under the Sixth Amendment, and she's anything but that. The fact that these proceedings have taken this long and through the convoluted way we've made it here today explain that. So as I present my arguments, I want the court to understand that this court represents the guardrails for the Sixth Amendment in this context, and Ms. Willis has already been disqualified once. So I would encourage the court to remember what Judge McBurney did in his order disqualifying. The same argument was made in that case as to whether or not there needs to be an actual conflict of interest or whether or not the appearance of a conflict of interest might be sufficient under the facts. I want to make clear to the court that the law in Georgia suggests and is very clear that we can demonstrate an appearance of a conflict of interest, and that is sufficient. I'm going to be candid with the court. There is a Supreme Court decision from 1996, Lambie State, and then there are two Court of Appeal decisions after that deal, frankly, in some dicta that suggests that an actual conflict is required. But the Supreme Court of Georgia, since those decisions came down, has made quite clear that the appearance of a conflict standard still applies. And the reason that's important is I think under the Sixth Amendment, which is where we're at, in order to preserve the defendant's rights under that provision and under corollary provisions of Georgia law, you've got to consider the appearance of a conflict. And the reason why the appearance of a conflict is so prescient here is because if this court allows this kind of behavior to go on and allows DAs across the state by its order to engage in these kinds of activities, the entire public confidence in the system will be shot. And the integrity of the system will be undermined. And so with those sort of public policy and constitutional principles, I wanted to turn to the law in Georgia on disqualification. And Your Honor, I'm going to give you the law, and then I'm going to talk about the facts and how they apply to the law at the end. If you want to talk about the facts earlier, jump right in, and I'll be happy to do that. I'm sure Your Honor is very well prepared and probably knows all the law that I'm going to cite to you. But to give the skeleton outline, the original seminal case that deals with conflict of interest from the Georgia Supreme Court is Williams v. State. That's 258 Georgia 305. And there are basically two methods by which you can disqualify a district attorney. One of them is a conflict of interest, and I'll suggest to the court that doesn't mean an actual conflict. That could mean an appearance of conflict as well, and then forensic misconduct. Importantly, in the Williams case, though, in footnote 4, and I think this is important for the court's analysis about the facts and which box it fits into, the court said there is no clear demarcation line between conflict of interest and forensic misconduct, and a given ground for disqualification of the prosecutor might be classifiable as either. And I think that's important because we have facts that fit in both boxes. So if a state stands up and says, well, there's no actual conflict here, Judge, that doesn't mean necessarily that it doesn't apply to the forensic misconduct. Typically, forensic misconduct relates to statements of the prosecutor designed to impugn the character of the defendant before trial and to affect the jury pool, which we have here, which I'm not going to discuss. But the facts that we have here very much relate to that issue, and there's crossover. Importantly, and I think this is important for the court's consideration of what effect the court's ruling may have, it is if you deny this motion, there's a good chance, if it's reversed, that we would be granted a new trial. So that means we're going to have to do this all over again. In amusement sales versus state, 316 Georgia Appellate 727. That's a case that cites Whitworth, which is physical precedent only. The court said, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify him, and the defendant is entitled to a new trial, even without a showing of prejudice. So that means if we show the court today, and I think we have through the proceedings today and before, that Ms. Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back all over again if the appellate courts say you were wrong.
So what is that personal interest?
So the personal interest can be, there's no definition of that under Georgia law, and it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct box. But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up. But to get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s, that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that here. We have something very concrete. And as Judge McBurney put it, actual and palpable, not speculative and remote. That's exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. In the seminal United States court case that deals with prosecutorial impropriety is Young v. U.S. That's a 481 U.S. 787 case. In that case, it's the opportunity for conflicts to arise that created at least the appearance of impropriety. And that's the case that requires that the prosecutor be disinterested. Since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant and impermissible factors into the prosecutorial decision. Now, there are a number of Georgia cases that sort of repeat that theme. Reeves v. State, 231, Georgia Appellate 22, that's a 1998 case, stated a potential conflict of interest existed and the appearance of impropriety existed. Davenport v. State, 157, Georgia Appellate 704, that's a 1981 case. That was decided 7 years before Williams. When there is at least the appearance of impropriety, a defendant is denied fundamental fairness in the state's prosecution of the charges against him or her. There are also rules that govern prosecutors. Lawyers in general are bound to preserve and avoid even the appearance of impropriety. That's Brown v. State, 256, Georgia Appellate 603, 202, 2002. Head v. State. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication of public interest. ABA Criminal Justice Standards for the Prosecution Function, Standard 3.1.2c. A prosecutor should avoid appearance of impropriety in performing the prosecution function. 3-1.7f. The prosecutor should not permit the prosecutor's professional judgment or obligations to be affected by the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. So the rules that govern her in her own profession say that this is wrong because she's developed a financial interest in this case. And at the very least, created the appearance of unfairness towards these defendants by setting up a relationship, a prosecutorial relationship with her boyfriend that she'd been dating for 2 years, according to the testimony. So before I move, Your Honor, to the specific facts, you asked, what's personal interest, and I think, frankly, as I was trying to figure this out, I think you know it when you see it. It's just like in the concurrence in Jacobellis versus State of Ohio, Supreme Court case from 1964, Justice Stewart, in his concurrent opinion, said, "I know it when I see it," talking about obscenity. I think you know it when you see it. I think there's enough facts in front of you that you know it when you see it. And so I think that the governing principle helps enlighten some of the facts here. And also, I think it's not just financial. In McLaughlin v. State, I think the court's very familiar with that case, 295 Georgia 609, 2014. The Supreme Court essentially said that because the acting DA had become a witness in the case and developed a personal interest in the case due to his daughter's relationship with the victim, that he was disqualified. And because he was disqualified, his entire office was disqualified. So turning to the facts of the case, Your Honor, I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people? We frankly couldn't care less if they had a personal relationship outside of work. That is not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years, and then she awarded him a contract where public money, either from Fulton County or the state of Georgia, ended up in his pockets. That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips. If Your Honor will remember, Exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back by Willis, because the cash reimbursement theory, I'll talk about in a second, but if you do the math on what he actually paid for it and what they testified she paid back in cash, you still have over $9,200, $9,200 and $9,247 to be exact, is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no mention of cash in Mr. Wade's affidavit. When the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there. The first time we heard about cash was here in this courtroom. And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for, and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. Cash theory only raises.
Before we get into that, let me ask you this. Let's say let's say the theory wasn't even there that they had paid it back or that there had been any exchange. Should there first be a consideration of a materiality requirement?
No.
Have you seen that in this jurisdiction? It's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Would it be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that giving a pack of gum is just justification for disqualifying a district attorney. I think that's part of the issue, Judge. I think it's a fact-based inquiry by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not, in the grand scheme of things, it violates the Constitution, and whether or not there's an appearance of a conflict, and the appearance suggests that she actually received a benefit, and we know that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit, and she said she paid back certain amounts. In that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly. Right. I mean, Your Honor sat here and watched everybody, so I haven't spent a lot of time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And just
from a legal perspective, though, you're saying we can't just say dollar amount, look no further. There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope then, because then it's going to be the appellate courts are going to be deciding, well, is $50 enough? Is $100 enough? So I think it's not necessarily the amount of the money, it's the fact that she received it, and it's not insignificant. And I don't think your order has to say because she received $9,200, she's disqualified. I think if we go back to the 20,000-foot level, what's the appearance here? Is this fairness to the defendants? Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes to the prosecution as a whole. I'm going to leave for I'll resist the temptation to defend my wife, who I believe to be an excellent lawyer and a member of the bar for 20 years in good standing. But I will say this, Judge, you don't just evaluate the credibility of the witnesses. You evaluate the credibility of the lawyers. And Mr. Abadi stood up here in open court in front of national news and the national public and called her a liar. I need to address that for 1 minute. This text messages that are now part of the record, which now are substantive evidence for you to consider, prove everything that she put in that motion, everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was accurate before it was filed. So for the state to get up here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You cannot lie to the court, cannot lie to the public, cannot lie to the jury. And I think that's what he did. So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to credibility. But Mr. Bradley had 2 chances to correct information that he suddenly developed amnesia about, and he just didn't do it.
How does the timing of the relationship impact financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to, every single question we asked Mr. Bradley was objected to, the jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that that relationship started in 2019, that the appointment of Wade itself was improper, and if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place. That undermines the indictment. It creates a structural impairment in the indictment because he had no more business being in the grand jury room than I did. So that's what they're worried about. And the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. That she created the system and then didn't tell anybody about it. She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality of the facts, and I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yurdy confirmed that Mr. Bradley, his text messages were accurate, not his court testimony, but that fact was accurate. The motion is accurate. And so also I do want to point out there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand, which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts. None of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what
But
we
does
know
the
about.
lack of evidence fall on the state? Does the lack of evidence fall on the state? Isn't that where burdens come in?
That's a good question.
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade, and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you, Mr. Merchant.
Appreciate the court's time.
Now, I got to say, John Merchant did an excellent job laying it out by saying that that there was an appearance of, or an issue of an appearance of there being some type of corruption. That's not the word that he used. I should have wrote the word down, but remember, I have $7.50 worth of law. And the appearance and actual corruption, and she had actual corruption. He laid it out beautifully. And I love the fact that he came back to defend his wife by saying that Fani Willis called her a liar as soon as she sat down. Liar. Called her a liar. And then Ashley worked feverishly to reestablish her credibility, which is very important. And she was able to get those text messages in, and those text messages corroborated everything, and they're in. And Fani got her fanny kicked, but I digress on that one. So.